Good morning, everyone. My name is Aroche from Mexico, winner of the bronze medal last year. I'm so glad to have won this award from my award entitled The Municipal Insolvency Procedure in Mexico as a Necessity. This idea came mainly from a presumption about the permanent solvency of governmental entities in my country, a myth that is repeated not only in Mexico, almost throughout in other countries, the reality being just the opposite. Governments also suffer from economic stress and therefore also suffer from insolvency. For this reason, it is necessary that the government also has tools such as insolvency procedures to mitigate the economic stress of governmental entities. Contrary to insolvency of companies or individuals, the insolvency of the governmental entities directly and immediately damages societies and the development of communities. In the case of my paper, I have focused on municipalities, because in Mexico, these entities have direct contact with the people, providing services such as potable water, sewage, maintenance and construction of streets, public security, public markets, and treasury collection. When there is not enough money available for municipalities to face their debt, the provision of these services mentioned above begins to be affected and in the long term causes irreparable damage to the people. Therefore, government insolvency procedures are regulated mainly to avoid the mentioned consequences and are regulated yet in some jurisdictions, such as Colombia, Hungary, and the United States of America. I have taken the experiences of these countries and the particularities existing in my country to develop a model applicable to Mexico. This paper, which was written early last year before the effects of the pandemic, has not lost its relevance, because the pandemic has aggravated the economy of all countries around the world, being an urgent call to pay attention to these insolvency matters. Because in many parts of the world, especially here in Latin America, the insolvency of a government is almost a taboo, when in fact, the governments of our countries should recognize it in order to solve it. Special thanks to the International Insolvency Institute and almost the audience of this Congress. Goodbye.
Hello everybody, I'm Dr. Oriana Casasola, and last year, in 2020, I've been awarded the Silver Medal for my paper, The Harmonization of Transaction Avoidance in the European Union, a Solution of Compromise. The paper put forward a set of harmonized rules that can be applied in cross-border scenarios. It also suggests new private international law to identify when a transaction can be deemed to be taken place in cross-border scenarios. And it applies harmonized rules only to those identified transactions. I am extremely grateful for this award, not only because it is an honor in itself, but also because it introduced me to the vibrant community of the Next Gen program and the International Insolvency Institute as a whole. So thank you very much, and I look forward to see you in person at some point.
Good morning, good afternoon, and good evening. My name is Ilya Kokorin, and I'm a PhD candidate at the Department of Financial Law at Leiden University. I'm also one of the winners of the 2020 prize in International Insolvency Studies. I would like to start by saying thank you to the International Insolvency Institute for choosing my paper. It's a great honor, and I'm really happy and thankful for that. So thank you very much. Today I would like to briefly outline one of the recent papers that I have published. It's titled The Rise of Group Solution in International Law and Bank Resolution. Traditionally, enterprise groups were not recognized in international insolvency law, but also in company law, even though in the economic realities of enterprise groups has been there. The insolvency rules have been focused on a single debtor. So we had this entity-by-entity approach, or what Jay Westbrook calls a legal armada of limited liability vehicles that insolvency law had to deal with, even though in good times they existed as a single economic enterprise. But what I notice and what I discuss in this paper is the appearance of group-sensitive solutions or rules in insolvency law and in bank resolution, which tend to address the group economic reality and provide for certain ways to accept and recognize that value in the context of insolvency. In Europe, we have Bank Recovery Resolution Directive from 2014. We have the European Insolvency Regulation recast, but also at an international stage in 2019, UNCITRAL proposed a new model law on enterprise group insolvencies. In addition, several jurisdictions have provided for the rules on group insolvencies, and Germany is one of those jurisdictions, for example. So what is a group solution? What is the rationale behind the appearance of these new tools? What are the manifestations and what are the limitations? So those are the questions that I look into in my paper. Well, a group solution is the concept that you may find in the new model law on enterprise group insolvency, but also in the European Insolvency Regulation, which refers to a solution that would leverage synergies across the group. The model law on enterprise group insolvency talks about a group solution as a way to achieve the goal of protecting, preserving, realizing and enhancing the overall combined value of enterprise group members. Bank Recovery Resolution Directive doesn't refer to a group solution, but it talks about group resolvability, which means that a group of banks should be allowed to fail without causing systemic risk and without being detrimental to the economy. So we see that it's more macroprudential compared to tools that address corporate insolvency, for example. Among the manifestations of a group solution that I look into are cross-border insolvency protocols, of course Lehman Brothers, but more recently LATAM Airlines insolvency included the conclusion of such a protocol. We see approval of third-party releases, very typical for restructuring financial obligations of enterprise groups, extension of an enforcement stay to group affiliates. Such an extension is available in Singapore, the Netherlands, Germany, to a limited extent in the United States. When we talk about bank resolution, there we have group sensitive tools, including group recovery and resolution planning, so the living wills that are adopted for the group as a whole. We have group financial support arrangements and tools to provide for the group financial support in a situation of a crisis. And of course, prepositioning of resources and liabilities within the group is another one. Yet what I look into as well is, what are the limitations? And most of the limitations for group solutions have to deal with an idea of limited liability and corporate separateness. So whenever that is at stake, we see the limitation of the group solution. For example, the best interest of creditors is defined on an entity-by-entity basis. Well, this is my current research, and I hope you enjoy it, and I wish you best of luck and stay safe. Thank you very much.
Hi, my name is Paulina Fishman, and I am a PhD candidate in law at the University of Adelaide in Australia. I am delighted that my entry for the 2021 prize in International Insolvency Studies was the bronze medal winner, and I am grateful to the International Insolvency Institute for this honor. The title of my paper is Insolvency Law to the Rescue and Zombies Arise. It traces the history of some of the biggest developments in insolvency law, including discharge of the debtor and corporate rescue, as well as the motivations behind these developments. New corporate rescue mechanisms have recently been introduced in countries including Australia and the United Kingdom. But also, there has been an apparent rise in the number of so-called zombie firms. My paper questions the relationship between these firms and the push for corporate rescue. I would welcome feedback on my paper and invite you to connect with me on LinkedIn. Thank you once again to the International Insolvency Institute.
Good afternoon. My name is Lydia Tsioli, and I'm the 2021 Silver Medal winner. Let me first of all thank the International Insolvency Institute for such a recognition of my research. I'm more than deeply honored and grateful for receiving this award. My paper is entitled Viability Assessment in Corporate Debt Restructuring, Optimizing the Filtration Effect of the European Directive on Restructuring and Insolvency. The paper focuses on the intricate notion of viability, a notion with double meaning and double role, which, despite being pivotal in corporate debt restructuring, has not been systematically examined in Europe. Against this background, and especially given that the European Directive is currently under transposition and restructuring law is making its first steps as a harmonized field across Europe, the paper undertakes a doctrinal, comparative, UK-USA, and economic analysis of law examination of viability with the aim of putting forward suggestions that will make viability the linchpin of the directive, thus optimizing its filtration effect. In doing so, the paper first distinguishes and analyzes the two different meanings of viability, namely financial viability and economic viability, and clarifies what the precise role of law is within the viability-related discourse. Such role consists in providing indicators of viability and incorporating appropriate filtering mechanisms, a term of art introduced by the paper, that will enable the filtering of non-viable debtors out of the restructuring procedure. The way in which such filtering mechanisms are triggered depends on who plays the role of the ultimate viability assessor within a restructuring framework, for example, an IP or a court. Depending on this, the paper distinguishes between IP-centered and non-IP-centered models of viability assessment and identifies the directive as standing closer to the non-IP-centered one. What the paper suggests, though, is that what ultimately matters most is the appropriateness of filtering mechanisms in any chosen model of viability assessment. Such mechanisms can be most characteristically found under US Chapter 11 and are the conversion or dismissal of a Chapter 11 case and stay relief under Section 362 of the Bankruptcy Code. The paper examines them extensively and demonstrates how the existence or inexistence of viability in its double meaning constitutes the litmus test for the triggering of Chapter 11's filtering mechanisms. In light of these comparative findings, the paper finally turns to the European Directive and first identifies its filtering mechanisms. The paper subsequently, and most importantly, makes suggestions on how the filtration effect of the Directive's existing filtering mechanisms can be optimized through appropriate interpretation, transposition, judicial practice, or future reform. Through these suggestions, it is aspired that first, the directive will properly reflect the notion of viability and consequently achieve an effective filtering of viable debtors from non-viable ones. And second, viability will ultimately become the primary point of focus and linchpin of European corporate debt restructuring overall. Thank you very much for your attention.
Good day, everyone. My name is Waegh, and I'm a PhD researcher at Erasmus University in Rotterdam, the Netherlands, where I research insolvency of shipping companies. It is my great honor and pleasure to present to you today the most important conclusions of my article with the title The Administration of Maritime Liens in a European Maritime Insolvency, Men Overboard. But before doing so, I would first like to thank the III for giving me the opportunity to present here today. And I would also like to especially thank the jury of the III's Prize International Insolvency Studies for awarding me with this great honor. Finally, I would also like to congratulate my fellow prize winners for their excellent contributions. So in my article, I analyze how a peculiar category of maritime security interests, called maritime liens, are treated and administered under the European Insolvency Regulation. Maritime liens are a category of security interests which are very particular to maritime law. They arise by operation of law, protecting claims that are considered crucial for the smooth continuation and operation of maritime commerce, such as, for instance, seafarers' wages, collision claims, or salvage claims. Now, the issue under the European Insolvency Regulation is that the fate of these maritime liens under this instrument is highly uncertain. In the article, I submit that without the protection of Article 8 of the European Insolvency Regulation, the famous exception for rights in rem, that without this protection, maritime lien holders risk losing the protection that they actually deserve. And they would lose this protection at a moment where they arguably need this protection the most, considering the financial turmoil that their debtor, the shipping company, is facing during insolvency. Moreover, the knock-on effects of not adequately protecting maritime liens under the European Insolvency Regulation would be considerable for European maritime commerce as a whole, taking into consideration how important these claims are for maritime commerce. Therefore, to adequately protect maritime liens under the European Insolvency Regulation, I suggest that maritime liens should unequivocally fall within the scope of Article 8 of the European Insolvency Regulation. And for this purpose, I identify two separate but complementary pathways to achieve this goal. Firstly, on a national level, EU member states should be more clear as to how they classify rights in rem, especially in relation to maritime liens. In the comparative analysis that I conducted in the article, taking into consideration 4 EU member states that are crucial for European maritime commerce, Belgium, France, Germany, and the Netherlands, in this comparative analysis, I came to the conclusion that the classification of maritime liens as rights in rem strongly depends on the relevant domestic law. But I don't see any reason why there should be any variation at all. So a first step in classifying maritime liens as rights in rem adequately under European Insolvency Regulation would be to have a more clear classification on a domestic level. Secondly, on the EU level, the scope of Article 8 of the European Insolvency Regulation should be refined so as to include borderline instruments such as maritime liens more adequately. So even though both of these suggestions or recommendations would require some reform, I believe that the changes would not be too drastic or fundamental, but they would merely be a refinement of the existing framework. In conclusion, therefore, it is not only necessary but also feasible to bring maritime liens back aboard the ship of the European Insolvency Regulation. This concludes my presentation. Thank you all for your attention, and I wish you all a great continuation of the conference.